Chair would now like to recognize Mr. Davis for
No,
his
thank you,
opening
Mr. Chairman. Let me say, we spoke with Mr. McDevitt on Sunday afternoon. He remains unusually passionate about his time at the White House Office of Administration. We can't understand his reluctance to be interviewed on the record, or why he wasn't compelled yesterday for testimony on the record. You've been very accommodating to this witness. Our staff's made it clear to your staff we wanted to examine him on the record, and his views on the situation, in my judgment, is colored by his apparent personal investment in various technology decisions that he made, and many of these were ultimately rejected. Without the opportunity to test Mr. McDevitt's views on the record, we remain skeptical of the content of his interrogatory responses, and we think the committee should as well. The preservation of essential records, though, is a government-wide responsibility and a growing challenge with so much more of the public's business done today using electronic media rather than paper. The massive proliferation of digital records confronts each branch of government with complex and potentially costly questions about which records to keep, how long to keep them, and how best to store and index them for retrieval. But it appears today's hearing may be less about preserving records and more about resurrecting this claim that the White House lost millions of official emails. It's a charge that is based on a discredited internal report conveniently leaked to the media. Information gathered since then has forced administration critics to back away from the politically charged allegation and acknowledge the less sensational but far more probative technical realities that are at work here. Regarding the capabilities of the White House's information technology infrastructure, the facts are not all in yet, and in that respect, this hearings could be viewed as premature, but we do know this much. During the White House migration from Lotus Notes to a Microsoft email system in 2002, some archive files may have been mislabeled, making them difficult to find using routine search protocols. A preliminary study in 2005 using these old protocols seemed to show 473 days of which no emails were sent at all. The White House has been very open with our staff about the technical flaws in that early search, and they have devoted substantial technological resources to solving the email glitch. One of our witnesses today, White House Chief Information Officer Teresa Payton, is leading that effort. Last Friday, she briefed the committee staff that the 473-day gap has been reduced to 202. So a substantial portion of the missing emails appear not to be missing at all, just filed in the wrong digital drawer. The restoration recovery process continues and should continue. But the committee's voracious appetite for White House emails raises another issue worth discussing today: the boundaries between legitimate oversight and counterproductive intrusion into the operations of a co-equal branch of government. Any frustration at the White House's inability to instantaneously produce every conceivable stream of electrons has to be tempered by both the legal rights and prerogatives and technical realities of modern government record keeping. The Presidential Records Act does not require the White House to keep every paper or electronic document generated in the course of daily business. The law requires presidential records to constitute adequate documentation of official deliberations and decisions. I expect we'll hear today that the White House is well aware of its obligations under the Presidential Records Act and other laws, and cognizant of the duty to preserve and provide adequate presidential records to the National Archives. And in terms of the scope of the oversight, we should keep in mind the power of inquiry, when used injudiciously, can become the power to distract or to disrupt those trying to execute the laws that we write. Remember where all this started: an investigation of the GSA administrator. From there, we moved to a far broader inquiry into the Hatch Act compliance at cabinet departments and a subpoena to the Republican National Committee for emails from the White House. From that inquiry, we came to this hearing to discuss emails about emails. At some point, this risks becoming investigation for its own sake, or for the sake of private plaintiffs looking to use the committee to conduct non-judicial discovery in pending lawsuits against the government. Nor is it the best use of our time and resources to attempt to micromanage executive branch activities like the next White House transition based on groundless suspicions or incomplete investigations into missing emails. Nevertheless, our witnesses can help us understand the intricacies and challenges of electronic records preservation. We welcome their testimony this morning, and I want to repeat, I think, as institutionally the legislative branch does have the right to pursue these and to get these emails. Mr. Chairman, thank you very much.